The Road Traffic Act, Section 64, duty to give particulars and place of residence and power of arrest in certain cases. Subsection 1. A driver of a motor vehicle who is alleged to have committed an offense under this act as to reckless or dangerous driving or careless driving, and who refuses, upon being so required by any person having reasonable grounds for so requesting or so requiring, to produce his driver's license or give his name, date of birth, and place of residence, or gives a false name, date of birth, or place of residence, commits an offense. Subsection 2. Any constable in uniform or on showing his authority as a constable may arrest without warrant the driver of any motor vehicle who, within the view of the constable, commits an offense under this act as to reckless or dangerous driving or careless driving, unless the driver either gives his name, date of birth, and place of residence, or produces his driver's license for examination, and the constable is satisfied as to the identity of the driver of the motor vehicle. So that means if the police sees you committing a traffic offense, you don't have your driver's license, and you have no other identification card on you to show your name, date of birth, or place of residence, then the police can arrest you. Section 65, restrictions on prosecution. Subsection 1. Where a person is prosecuted for an offense under Section 55, 58, or 59, the person shall not be convicted unless A. The person was warned after the person committed the alleged offense that the person may be prosecuted for the offense. So the police would have to warn you. Right? Warned after the person committed the alleged offense. So warn you that you can be prosecuted, so you can be warned for prosecution. B. Unless a summons was served on the person within 14 days of the commission of the offense. So once 14 days pass, they cannot prosecute you. C. Within 14 days after the offense was committed, a notice of the intended prosecution specifying the nature of the alleged offense and the time and place where it is alleged to have been committed was served on or sent by a registered post to the person or to the person registered as the owner of the motor vehicle at the time of the commission of the offense. Subsection 2. A failure to comply with the requirements of subsection 1 shall not prohibit the conviction of the accused by in any case where the court is satisfied that A. Neither the name and place of residence of the accused nor the name and place of residence of the registered owner of the vehicle could, with reasonable diligence, have been ascertained in time for a summons to be served, or for a notice to be served, or sent in accordance with subsection 1c. So here, you can, even with conditions in the previous section, if your place of residence or name is not, they're not able to get it, right? Once you're found, you can be prosecuted. All right. B. The accused, by his own conduct, contributed to the failure. So you try to hide your identity from the court. Then here, even with the previous conditions here, the 14 days limit to serve the summons on you, or you were not warned before for prosecution, then here you can still be prosecuted if the court cannot determine where you live, what your name is. All right? Or if you took action to delay the court finding out such information. All right, subsection 3. The requirements of this section shall in every case be deemed to have been complied with unless the contrary is proved. All right. So the assumption is that all requirements of section 65 have been complied with by the court unless you can provide proof that it was not complied with. All right. Part, this would be 7. Driving under the influence of alcohol or other drugs. Section 66. Driving under the influence of alcohol or other drugs. The provisions of the 5th schedule shall have effect as to driving under the influence of alcohol or other drugs. In our next video, we will look at Part 8, Special Provisions as to motor vehicles.